The facts matter.
Good morning, everyone, and welcome to Snoop for Truth. I am Virgo, and it is December 13th, 2019. Last week, we talked about a few things having to do with RICO and federal RICO, to be specific. Now, we were talking about civil RICO at the time, but we're going to talk a little bit about both today. A lot of you asked for information pertaining to this from Snoop, and he rose to the challenge as always. We're going to be going over Snoop's information so that this way you guys actually have the information on how you can go about recouping your money, or at least being able to go after some of these individuals who may have defrauded you. Now, the majority of these individuals are spreading what's called the redemption theory. They're making claims that if you do things like file UCC1 financial statements, you will be able to pay off all of your debt without you actually having to be the one to pay it. Many of the claims entail you being able to send in accepted for value presentments to the Treasury, for example. All of these things are lies, none of them are true, and there are no secret accounts. With that being said, many of you will not believe what it is that Snoop, who happens to be an expert legal mind and an attorney, are going to say in this video. However, keep this video on your watch list, even if you hide it from everyone else, because sooner or later, you're going to realize that if you've purchased one of these packages, you will need it. If you've paid to attend any seminar or class or paid for any written or recorded materials in reliance upon a fraudulent representation made over the internet, or which involve the sending of money in any way, shape, or form having to do with the United States mail, or by PayPal, or by merchant account, you may have a claim against the wrongdoers under federal RICO law. So if you've paid to attend any seminar involving, for example, Rod Class, in reliance of his fraudulent claims that number one, he is a private attorney general, or number two, he can train you to be a private attorney general, or that he knows, number three, the law, or that, number four, he rather than the attorney involved has ever won any case in any court at any time in which he was involved, then you may recover 3 times your money back plus attorney's fees plus other legal costs under a federal RICO civil action. Now listen up, folks, this is important. You may also recover actual damages and punitive damages in the same action under state law. Finally, you may file criminal charges against those responsible under the federal RICO criminal law, but in every such case, you must take action before the applicable deadlines expire. Here is the basis for federal rather than state jurisdiction. Note, where I'm using Rod Class again for this example because let's face it, he's a good one to use. Rod Class markets and solicits money for his seminars by using the means of interstate commerce, internet email, telephone, U.S. mail, etc. Rod Class markets and solicits money for his seminars by making the fraudulent representations that I just described. These fraudulent fraudulent conduct gives rise to federal jurisdiction because it crosses state lines. This fraudulent conduct also gives rise to claims under federal RICO and gives rise to state law claims for fraud and misrepresentation, which can be made in the same civil lawsuit. Does this sound familiar to you guys? Okay, these people that represent themselves online in internet seminars, etc., many of them, aren't there? So you ask, does federal RICO really apply to the acts of charlatans who commit fraud while using a means of interstate commerce like the internet to market seminars, classes, books, recorded materials, or memberships? Yes. See actual proof in the cases I'm about to show you. The first case I'm going to be summarizing, and the link to this case will be in the description of this video for you to take a look at for yourself, is Kneeble versus Transworld Assurance. Now, this case involved a charlatan and his affiliates whose interstate advertisements promised seminar customers that they could reduce their income tax liability to zero. But this claim was not so, and the seminar customers not only had to pay the full amount of their taxes, they also had to pay the IRS hefty late fees, fines, and penalties for making phony tax deduction recommended in the seminar. So, a seminar customer sued the charlatan and his affiliates under federal RICO and won a very large verdict at the jury trial. The charlatan and his affiliates appealed and made a number of technical arguments as to why the federal RICO law did not apply to the case. But the Court of Appeals disagreed and shot down every argument made by the charlatan and his affiliates and affirmed the judgment of the trial. For those of you that are going to use the link in the description to actually read the case, look for the following terms and phrases in this case. The defendant here preyed on Americans with little experience in the tax laws or the legal system, exactly like Rod Glass does. At his seminars, the defendant here promised those in attendance that they could lawfully reduce their income tax liability to zero, just like Rod Glass promises in his own seminar customers, The defendant also promised those in attendance that he would provide them with legal document preparation and advice and legal protection, just like Rod Glass promises in his own seminars. The preceding text is in the third full paragraph at about 10% through the text of the case. The defendant here describes his methods and his documents as tried and true, just like Rod Glass describes his own methods and his own documents to his own seminar customers. Despite the defendant's promise that nobody ever lost a dime under his scheme, the defendant's clients incurred severe IRS penalties for late payments and overstated deductions, just like Rod Glass's own seminar customers and clients incur, such as Harold Stanley, who went to prison for 5 to 8 years. The immediately preceding text is in the sixth full paragraph at about 20% through the text of this case. Translation. The defendant here, like Rod Glass, lied to his customers about the benefits that his seminar customers would receive from attending his seminars, such as becoming a private attorney general and winning cases in court, etc. The jury here found the defendant liable for violating federal RICO Section 1962D and awarded the plaintiffs $259,366 in actual damages, tripled, to $778,098 under federal RICO 18 U.S.C. 1964C. It, meaning the jury, also awarded the plaintiffs $87,000 in damages for fraud and misrepresentation under state law. Finally, the jury awarded the plaintiffs $500,000 in punitive damages under state law. The immediately preceding text is in the 8th full paragraph at about 25% of the way through the text of the case. Thus, under the law, charlatans like Rod Class are liable to their seminar customers for triple their losses under federal RICO, plus attorney's fees and costs, and liable to their customers for actual and punitive damages under state law. In the next case, we're going to be looking at Gutierrez versus Givens. This case involved a charlatan and his organization, which sold memberships and seminars, promising to increase the wealth of every member through ongoing financial advice. But this claim was not true. So a number of members formed a class and sued the charlatan, his organization, and others under federal RICO for making knowingly false statements about the benefits of membership in the organization. In anticipation of such suits from disgruntled members, the charlatan, his organization, his attorneys, banks, and others had already created a scheme to hide all of the money and other assets derived from the fraud in which they engaged. But the members found out and sued the others that were involved also. Every party sued moved for dismissal, which, if granted, would have ended the case in favor of the charlatans. In support of their motions, the charlatans argued that federal RICO law did not apply to the case. With the exception of an argument from a bank which was sued, the court shot down every argument raised by all of the other charlatans and denied the motion to dismiss as to every other charlatan sued, which resulted in the case continuing in favor of the member victims. For an excellent explanation of federal RICO applies to such memberships and seminars, read Section 2 of the case in its entirety. It begins at the 21st paragraph and reads, could plaintiff's pleadings state a RICO claim against anyone? The link for this case, of course, will be in the description of this video for you to read and follow along for yourself, should you like to. The next case we are going to be talking about is Maita versus Sherman. Of course, the link will be in the description for this also for you to take a look at. This case involved a charlatan and her affiliates who peddled a credit repair scam, among other things. The charlatans promoted the credit repair scam in seminars held in churches and hotels, also in educational facilities, and used the means of interstate commerce, phone, United States mail, internet, etc. in the process. The charlatan and her affiliates claimed to be capable of performing credit repair and claimed to have improved their own credit scores and claimed to have received many other benefits from the credit repair program, including zero-interest loans and zero-interest credit cards. The charlatan and her affiliates demanded to obtain $1,698 in advance from their victims for their promised services. But afterwards, the charlatans did nothing to improve the credit rating of their victims. Indeed, the credit rating of many of their victims actually became much worse. So the victims sued the charlatans under federal RICO and moved for summary judgment, which, if granted, would end the case in favor of the victims. In response, the charlatans argued that federal RICO law did not apply to the case, but the court held otherwise and granted final judgment, including damages, in favor of the victims. A little side note that you guys will want to keep your ears perked for. 18 U.S.C. 1959 B2 defines enterprise for RICO purposes as follows. Enterprise includes, but is not limited to, any partnership, corporation, association, or other legal entity, and any union or group of individuals associated in fact, although not a legal entity, which is engaged in or the activities of which affect interstate commerce or foreign commerce. Even a single person is an enterprise under RICO. This case will be located for you to read in the description below. Just to let you guys know, Something that I found particularly interesting that Snoop sent that will be linked in the description below is a RICO case involving President Trump. So here's the conclusion, folks. If you paid for a seminar or class, or for other written or recorded materials that have been advertised over the internet in reliance upon fraudulent representations made by a charlatan, like Rodney Judge Dale class, Deborah Jones, Eddie Craig, Dean Clifford, April Lejeune, Druanna Johnston, Moneyboy Films, etc., then you may recover 3 times your money back, plus attorney's fees and costs under federal RICO. In addition, you may also be entitled to actual damages and punitive damages under state law. Furthermore, you can also go file criminal charges, criminal RICO charges against these entities, such as Sharon Tracy Gale Bay, Moneyboy Films, April Lejeune, Druanna Johnston, Rod Class, and so many more. Before closing out today, I want to say that Snoop has been wonderful to us as a legal expert and whistleblower. Snoop has this statement that I'd like to read to you. I read it to you last time, and I think I will continue to read this so that the charlatans, the hoaxsters, the fraudsters, the con artists can hear it and understand that the party that is actually exposing a lot of these individuals actually is a legal expert, actually is someone that they need to be concerned about. Because, let's face it, there's thousands of these people that defraud individuals on a daily basis. And quite frankly, those of us that are part of the watchdog groups are sick of it. Snoop for Truth is a legal expert and whistleblower who exposes online hoaxes. Snoop for Truth did not reveal any of this information to harm any of the specific hoaxers or con artists. Snoop revealed this information solely to reduce the catastrophic damage that such intentional fraud inflicts upon the American people every single day. The message to all of you charlatans and hoaxers from Snoop is the following. Just tell the truth. The truth does not fear investigation. Only lies fear investigation. The truth can be supported using the truth. Only lies must be supported by using hoaxes, other lies. There is no such thing as a good reason to intentionally defraud the American people, not even to make a popular and sensational conspiracy theory appear to be true. I hope everybody enjoyed this. If you have questions for me or for Snoop, please put them in the comments section, and I'd be happy to pass them on for you and get answers for you. Everybody take care, have a wonderful day, and watch it out there on the internet. There are people wanting to take your money.